Call our last case of the day and of the October call, People versus Lemons. This is a mini oral argument on the application, 15-minute argument per side with 5 additional minutes for amicus American Academy of Pediatrics.
Clock is currently set at 15.
I have you at 15 and 5 for amicus.
The court ordered that they would get 5 minutes and my time would be extended by 5 minutes.
What?
The court ordered that my time would be extended by 5 minutes.
Meaning 20 minutes?
Yes.
You have 20 minutes?
Yes, Your Honor.
I don't have that on here. I apologize. Is that your understanding as well? Okay. Can you reset the clock to 20 minutes, Jeff? Okay, go ahead.
With that glitch out of the way, Your Honor, may it please the court, David Moran from the University of Michigan, Michigan Innocence Clinic on behalf of Ms. Lemons. I'm joined at council table by a crew, co-counsel Imran Syed and Elizabeth Cole, and student attorneys Samuel Clawher, Aviva Diamond, and Daniel Euclid. In this case, and I will happily waive my free fire time as well, Your Honor. And I'm going to try and reserve it 4 minutes for rebuttal. 2017, the medical examiner, the only person to examine the decedent in this case, Dr. Bader-Casson, came into court and retracted his diagnosis from 2006 that this was a case of shaken baby syndrome. He also retracted his finding of homicide, changing it to undetermined, and he agreed that it is entirely plausible and possible that Nikita Lemons died from choking on formula. In addition to Dr. Casson, we presented 5 other eminent experts, including the head of pediatric neuroradiology from Stanford, a professor of pathology from the University of Louisville, who had been the chief medical examiner for Kentucky for 20 years, an esteemed biomechanics expert, Dr. Van E., who's actually present in the courtroom today, a neuropathologist professor, all of whom agreed that the shaken baby syndrome diagnosis in this case was unsupportable, and most of whom agreed that it is entirely plausible, entirely makes sense that Nikita Lemons died from choking on formula, just as many of the lay witnesses noticed that formula was coming out of her mouth. Indeed, formula was suctioned from her mouth when she was taken from the hospital. Given all of that evidence, a new trial was required. But the trial court ruled that none of this evidence would be considered at a retrial, with the possible exception of Dr. Casson's retraction, because the trial court decided under Daubert that anyone who was attacking shaken baby syndrome must be wrong. And that is not how Daubert is to be interpreted. Daubert allows for scientific debates. It is not a search for the one right answer in this case. The Court of Appeals in this case correctly found that the trial court abused its discretion, both in treating Dr. Casson's retraction as if he was a lay witness recanting, and in excluding all of these eminently qualified experts, none of whom had ever been excluded before, even though most of them had testified scores of times in courts high and low around the country. And all of this is consistent with this court's unanimous decision in People v. Ackley from 2015, just 2 years before this evidentiary hearing in this case, where this court unanimously recognized that there is a prominent dispute about the validity and reliability of shaken baby syndrome diagnoses. Indeed, since Ackley came down and since the evidentiary hearing in this case in 2017, more and more courts have reached the same conclusion, to the point now that there are 30 people in the United States, at least 30, who have been exonerated after shaken baby syndrome-based convictions in at least 20 courts, including at least 5 here in Michigan. But the Michigan Court of Appeals held that all of this was neither here nor there, despite agreeing that the trial court had abused its discretion in large part, because the Michigan Court of Appeals concluded none of this would make a difference for 2 reasons. One, that Ms. Lemons confessed, and 2, how she behaved when Nikita Lemons collapsed. turning to the first of those, the confession, courts around the country since 2007, including the U.S. Supreme Court, have recognized that false confessions are far more prevalent than we had previously believed. And in particular, we have decisions from the Seventh Circuit in the Ellman case. We have decisions from the New York Court of Appeals in the Thomas case, recognizing that when a parent is a grieving parent, in this case, Ms. Lemons was arrested the day her baby died, and she was held overnight and interrogated, that it is not at all surprising that when you confront somebody with a supposedly indisputable medical diagnosis, that they are willing to agree to that. As to her behavior, if she was trying to cover up for having done something grievous to Nikita, you would not think that she would do what she did, which is run to the neighbor's house, call her spouse, call her mother-in-law. Instead, you would think that she would just leave Nikita there instead of exposing her to other people who could assess her condition. 911 was called. She delivered blows to Nikita's back to try and stop the choking. None of that is particularly suspicious, but more to the point, this court recognized in Ackley that what looks like suspicious behavior may not be suspicious behavior when it's considered altogether. But the point of all of this is that this is all for a new jury to decide. This is all for a new finder of fact to decide. Do they believe our eminent witnesses, or do they believe the prosecution's experts that they called at the evidentiary hearing? Do they believe Dr. Casson got it right the first time, or did Dr. Casson get it right when he came in and testified in front of the trial court in 2017? So all of this taken together makes for a very strong case under People v. Kress of reasonable likelihood of a different result. Now, there's one other dangling point here, which is, I say the Court of Appeals got it right. They got it mostly right about the trial court's mistakes. The one mistake the trial court made that they upheld was the exclusion of Dr. Van E., the biomechanics expert. And they concluded that Dr. Van E.'s conclusions did not pass the Daubert test under Joyner because there's too great an analytical leap, because he, like all biomechanics experts, use models in order to determine the forces that are inflicted with various scenarios. And so Dr. Van E. relies on the use of biofidelic dummies. He relies on the use of computer modeling and also animal studies. Because of course, everyone agrees you cannot ethically shake children to see what would happen, or to shake infants. And the Court of Appeals concluded that evidence is so tenuous that it should be excluded. That was an error on the Court of Appeals, and of course that drew the amicus brief that we got from General Motors, because General Motors relies on experts, including Dr. Van E., who has testified scores of times, not just in infant cases, but in other cases involving automotive liability, consumer products such as child helmets, infant car seats. So biomechanics experts are an integral part of the automotive industry and many other industries when we're designing for safe equipment. And the Court of Appeals reasoning there would be no reason to confine it to this type of case. There's no reason why that wouldn't apply to other types of cases. And so the trend here is clear. Despite what the amicus brief or the other side says, courts around the country have continued to hold over and over again that shaken baby syndrome is a disputed theory that the jury or fact finder needs to hear from both sides, which did not happen here at the trial level, which is why we need a new trial. And so the trend is clear both in the courts and in the science. In 2017, the same year that this evidentiary hearing was held, the SBU, which is the Swedish equivalent of the National Institutes of Health, took up a challenge that had been laid down by the Swedish Supreme Court. In 2014, the Swedish Supreme Court issued a holding that they would not consider shaken baby cases anymore unless there was a good scientific basis for them. And so the SBU took up that challenge, and in 2017, a massive study was done in which not 70 articles, as the amicus brief claims, but over 3,000 articles about shaken baby syndrome were examined by a panel of eminent experts, and they concluded that the evidence base for shaken baby syndrome was very weak, and that in particular, the hypothesis that you can accurately diagnose shaken baby syndrome from a few symptoms was very, very weak. And so it is not just the courts, as the amicus would have you believe, that are holding this. It is the scientists. More and more studies have come out. There are more and more experts who are testifying around the country that shaken baby syndrome diagnoses are doubtful. But let me cut to the core here. The question is not, is it possible to shake a baby and produce these particular injuries without fracturing the neck? I mean, that is certainly a question that the scientists are wondering about, that the biomechanics experts are working on. But the question is can you accurately diagnose shaking to the exclusion of all else by the presence of a few symptoms? And they will tell you that it is a straw man to say that the proponents of shaken baby syndrome just use the triad of symptoms. And I hope that that's true now, but it was not true in 2007. When Dr. Casson testified in 2007 at the trial, he made it eminently clear, he said so, that he relied on these three symptoms in the absence of another obvious cause. And when he came back in 2017 and testified and retracted his testimony, he agreed that that's what he had done. He had relied on the triad of symptoms. So if experts today are not exclusively relying on the triad of symptoms, that's good. But in this case, that's what happened. And what everyone agrees, including the American Academy of Pediatrics, is that there are other causes for these symptoms. Back in the old days, about the time that Dr. Casson testified, very few other things were thought possible to cause the symptoms that Nikita Lemons had. But we now know that that's not true. We now know that other causes, including causes that cut off oxygen to the brain, can induce swelling of the brain, bleeding of the brain, and bleeding behind the eyes. And that wasn't thought to be true back in 2006 when Dr. Casson testified at trial, but when he came in and testified at 2017, he now knew, based on the biomechanics evidence, based on the evidence of the other things that can cause shaken baby syndrome symptoms, he no longer believed that it was at all implausible that Nikita Lemons died from choking to death on formula, despite the best efforts of her father, the EMS people who responded, and the neighbor. So for all of these reasons, we ask that this case be sent back for a new trial at which a jury of Ms. Lemons' peers can hear all of this evidence together and make the determination one way or the other. Thank you.
Reserving. Reserving?
Oh, yes.
The rest, okay.
Good afternoon, Your Honors. Dan Hebel on behalf of the people. Facts. That's what makes this case different from all the other cases that counsel was talking about. Cases in different areas, the SBU study, GM using biomechanists in their cases. Facts. You see, Dauber isn't this broad analysis where, well, Van E testified in this case, so he can testify in all cases. No, it is very fact-specific. The courts are the gatekeeper of science. That is the underpinnings for Daubert, for Joyner, for Kumo, and for this court's case of Gilbert. And that's what makes this case different. That's what Judge Kenney recognized. That's what the Court of Appeals recognized to some extent. And with that, I'd like to point out that the Court of Appeals was right and the Court of Appeals was wrong about different things. Well, the Court of Appeals was right in that this evidence would not change the outcome of trial. Let's start off with the fact that Tim Kenney, the trial court, the judge who heard this hearing, was the fact finder at the bench trial. And he found that this would not make a difference at retrial. let's also take a look at some of the interesting facts. Defense was just talking about how, there's false confessions out there, and we have a new body of false confession law. We do. And it's very interesting. And it didn't happen in this case. Because, yes, when the police confronted defendant wrote out a complete confession, complete with, I was afraid to be left alone with the baby. And the baby wouldn't stop crying, which is why I shook the baby. I shook the baby at a 7 in strength, where 10 would be the hardest and 1 would be the weakest. And the victim immediately vomited, her head rolled to the side, and she stopped breathing. Now, that was the final confession. What happened before that? Well, at Annapolis Hospital, defendant suggested to Lori Lemons, maybe this happened because I shook the baby. And then at U of M Children's, defendant said, maybe this happened because I shook the baby. And then to the police, defendant suggested shaking as the cause of injuries before the police brought it up. This is not a false confession out of the blue where the guilt piles down and the police said, you did it, and I must have. No, this was defendant's theory all along.
Counsel, can I get to the question of the admissibility of Dr. Van E's testimony? Mm-hmm. And what I'm struggling with is what seems to me to be an inconsistency in. Would you agree with me that the prosecution's experts relied on biomechanics in arriving at their diagnosis of shaken baby syndrome? No. They didn't rely on it at all.
Biomechanics was not the foundation for their diagnosis. Their clinical experience was the foundation for their diagnosis. Okay,
so I want to reference the testimony at the evidentiary hearing of Dr. Davis, who discusses how he used computer modeling to create an inanimate model as biofidelic as I could. Mm-hmm. Talks about using silicone and water on the brain and to try and figure this out. You don't believe that's biomechanic?
Oh, that's definitely biomechanic, but it's not the foundation for his
It's partly.
Belief. I believe, if I may?
Sure.
I believe we're conflating two different things.
Okay.
One is, what did the people rely on? Well, the people relied on clinical experience. Biomechanics was introduced to the case by the defense because they believe that studies show that this is biomechanically impossible. And quite frankly, that's a key element of the defense.
Well, I mean, not to be glib, I mean, it's literally in the name, shaken baby syndrome. Mm-hmm. It's not sitting in a high chair baby syndrome, right?
Correct.
I mean, it literally implies that the causation is related to the force exerted on the body. Yes. So, and then the two experts talk about how they arrived at that, at least in part, relying on, based on my review of their testimony, biomechanic principles. And then I look at, the Court of Appeals says that Dr. Van E's testimony is not admissible because it's what does it say? It's unreliable because it extrapolates data from animal studies, physical modeling, and computational modeling and recorded data. And I'm struggling to see why the prosecution's experts don't rely on that very same thing. And so why is it sufficient? Why is it admissible? Why does a jury get to evaluate that? Now, there may be at the end of the day, those experts could explain away why these experts say, nope, here's why I don't think they did it right. I think silicone is different than this. I think a piglet's brain is different than this, or I think their methods were shoddy, all that. But it's both biomechanical science. It's both drawing from the same methodology of computational modeling, animal studies, and physical modeling. Why is it not, at a minimum, admissible for the jury to determine who is more believable?
Because this is an issue-by-issue analysis. It's not just, does biomechanics come in? If so, all biomechanics comes in. Does physics come in? If so, all physics come in. You can take a physicist, put a physicist on the stand, show him a stretch of road, and then he says, well, yes, this piece of road is definitely flat. In fact, there's a study that says this piece of road is definitely flat. Therefore, the earth is flat. Is that admissible? It is not, because there's three different things. It's not just the expert, okay? I don't have problems with Van E as a biomechanical expert. And it's not just the study, but Joyner points out that the deduction drawn from the study must also be reviewed. And that was the problem. Saying you can shake a piglet one time and not cause retinal hemorrhages, okay? That doesn't say anything about shaking a human being, infant, multiple
I would
times.
agree, but that, I mean, I think we're talking about different things, because the prosecution's expert said literally you can, based on whether one or multiple times or however many times you shake a piglet's head, that is in part forms the basis for my belief that there was shaken baby syndrome. And I guess maybe this is where, and maybe this is maybe better directed to amici counsel, but like this idea that shaken baby syndrome denialists, or whatever you want to call them, is junk science, I'm struggling to see how maybe the results are different and the conclusions to be drawn from that are different, but the science is the same. The science is the study of the exertion of force on the body to determine that. Nobody can do it on live human beings, for babies, for obvious reasons. And both sides are relying on inanimate models, you know, bioforms, crash test dummies, however you want to say it, computer modeling, and animal testing. Why is one admissible and the other is not?
Okay, let me be very blunt. They're not. My case at the hearing was a Daubert case. I was explaining that biomechanics doesn't say one way or the other. Okay, yes, my experts say the biomechanics does not agree with the defense all the time. In fact, very often, the more biofidelic the model, the more likely it is to show shaken baby syndrome. But what we're looking at is a fringe science directed at forming conclusions that are not scientifically accurate. And the reason why is, for example, I think this speaks to your question exactly. The piglet study, which we just talked about, and you agree that doesn't show shaking in a human being. Well, how about the lamb study? The lamb study, which is much more like a human infant, you have a very large head, a weak neck muscles in a young lamb. When those are shaken, they sometimes die.
That's the result. You think the lamb study is more believable than the piglet study.
No.
But here's my problem. The Court of Appeals said those kind of studies, be it a lamb or be it a piglet, are not reliable because they're based on animal modeling.
And the Court of Appeals was right. My lamb study is no more admissible than their piglet study.
Well, it was your expert's piglet study.
Yeah.
I guess maybe we're talking.
All of the studies that were introduced with the biomechanics, okay? Some show this, some show that, some are completely off topic, okay? And in the end, none of them can actually form a deduction as to what would happen when you shake a baby. The way you form a deduction of what happens when you shake a baby is you look at actually what has happened when people have shaken babies. Okay? Biomechanics is not there yet. All of the injury models, both of the ones that say you can shake a baby and cause internal head injury, and the ones that don't, they don't rely on an injury model which is based off of a human brain. They don't rely on an injury model that has anything to do with an infant at all. They rely on a single acceleration, instant deceleration event where a monkey, a primate that's strapped into a car seat, is accelerated and then stopped. What was that test designed to do? Crash test safety. Okay, how does it apply to shaken baby syndrome? It doesn't. And that's the issue. If my experts introduce something to say, see, it doesn't happen all the time, okay, that doesn't mean my experts should be allowed into court to say, see, you can shake a lamb and that's going to cause shaken baby syndrome. No, that's not a proper comparison, because that is a huge analytical leap that we're going to all sit back and pretend that a lamb that is shaken is like a human infant in a cyclic shaking motion.
And none of those types of studies go into or form any part of the basis of a diagnosis of shaken baby syndrome.
They do not.
They have no relevance whatsoever. Your experts, and for no part of it, that none of that factored into, no biomechanical principles, let alone animal computational model studies. No principle of biomechanics factored into the conclusion or the diagnosis of shaken baby syndrome.
No, because in this case, it was testified by the medical examiner exactly how he came to that conclusion.
And, okay, I get it.
And when we're talking about the hearing, yeah, I'm going to put on experts from all different fields, which, by the way, is if you look at these other cases, a lot of them around the country, the prosecutors didn't do that. They put on one witness that said, oh, well, I was told by the American Academy of Pediatrics and maybe some other people that this is the way it is. So there. We had a representative from the American Academy of Pediatrics. We had a representative from the Society of Pediatric Radiology. We had a representative from the National Association of Medical Examiners all testify at our hearing, and they all found the same thing. Shaken baby syndrome is real. Abusive head trauma is real, and it's been real since long before biomechanics came onto the field.
Go back to the beginning of your argument where you talked about defendant stating several times that she shook the baby.
Yes.
Do we need to think about I believe it was the third time, the last time, where she indicated shaking the baby, that it was only after the autopsy came back, and that was the only time that she said that she shook the baby not to wake the baby up. I think the first couple times was the baby was sleeping, I was trying to wake the baby. And then the last time it was, excuse me, after the autopsy, and when the detective brought that to her attention, that she said, I shook the baby when the baby was awake. Mm-hmm. Is there any concern there that's different, that we need to look at that differently, that there's any coercion there?
Not at all. In fact, I would welcome the court to examine the entire transcript. I would welcome the court to look at that intently, because there was no coercion. It was just the police officer saying, well, yeah, this child was shaken to death. And at that point, we have this entire confession in detail. And I think in that way, the Court of Appeals was right. This is not like the vast majority of shaken baby syndrome cases where there's a real question as to how and when the child died, whose custody the child was in. This case, we know exactly when the child died. We really know exactly why the child died. That's what the defendant was saying again and again. And I would ask that this court, if it's going to render opinion in this case, I mean, the court could dismiss the application, but if it decides to render an opinion, I would ask that the opinion be on Daubert, because that's what the Court of Appeals got wrong. Daubert isn't a broad analysis where you just look at a single type of science and ask yourself, should everybody come in or nobody come in? Rather, it is each principle should be looked at individually, and you have three things to analyze. First is the expert. Is the expert actually an expert? Second question is this study actually a good study? And the third question is the deduction taken from that study scientifically reliable? And that's the Joyner question. All three of those must pass, otherwise it's scientifically inadmissible. And this court, as the trained gatekeepers, and all the lower courts, as the gatekeepers of science, need to make that determination. Otherwise, we risk false science getting into the court. Thank you.
Thank you.
May it please the court, David Porter here on behalf of the amici medical societies. We thank the opportunity to present argument here today. In my short time, I was going to address the question that really neither party has answered, but I think is really important, which is why it matters. But I do want to take an opportunity to answer Justice Kavanaugh's question. The medical society's position on that is that debate between these two experts should be happening not in the courtroom, but in the clinic or in the research lab. Biomechanical engineering is a promising, a useful adjunct to the AHT diagnosis science, but it has not proven the propositions that have been asserted here today that shaking a baby cannot cause the type of injuries that we see in AHT.
Is it relevant to showing that shaking a baby can cause those injuries?
Neither way. The biomechanical engineering has not proven the proposition one way or the other.
I'm not saying proving it, but do experts or doctors who diagnose shaken baby syndrome have to have some foundation, whether it's because of a study that they've read or what they've been taught in medical school or they've been taught by, other doctors, whatever it is that shaking causes shaking baby syndrome. The exertion of force, and we can dispute size of heads and how many times and which direction and rotational forces and all that, but that exertion of force on a baby's body can cause those medically diagnosable conditions.
So the confidence of that conclusion, of that diagnosis, comes from decades of medical literature, observational studies that confirm that the presence of a constellation of certain injuries is statistically significant or associative of a particular type of inflicted harm. So that's where clinicians are getting the basis for the AHT diagnosis, not on one particular study of a biomechanical engineering. Now, the problem here is that science is not static. It's always evolving. And they're taking advantage of that by holding up one biomechanical study and saying, well, look, now this casts doubt on the entire...
But was there one biomechanical study at some point on which the clinicians based the fact that shaking or applying any force or no force at all, any force causes the conditions that are seen? It has to start somewhere, right?
Correct. So with respect to biomechanical engineering in specific, no, there was not one study that said, oh, okay, now we know that if you shake a baby, this will happen. This happened gradually over decades when more and more observational studies, findings, you have experts from all different fields, radiologists, ophthalmologists, pediatric abuse physicians. All of these cross-disciplinary specialties come together and they see the same findings time after time, and they are able to associate that with a certain type of inflicted harm. Now, what happens with this in the scientific process is that more and more inputs are put in year after year, and this will develop the scientific body of knowledge. It will be able to refine how they make this diagnosis. So clinicians, pediatric physicians see promise in biomechanical engineering. It just hasn't developed to the point where it can be useful to support the propositions that are being put forth by the experts in this case. That's why this case is so important, because they come in and they testify that this could not possibly happen because we have yet to validate it with biomechanical engineering studies. It doesn't disprove the decades of observational studies and other types of medical literature that have time after time demonstrated the types of injuries that can occur when you inflict this type of harm.
Based in some part on an understanding of a certain type, degree, amount, character of force applied to the child's body.
Correct, because and biomechanical engineering is not a field separate in and of itself that doesn't include physician input. The reason why you have biophydetic models is because they work with clinicians, the same people who are treating these babies, who know the tensile strength of a certain musculature. They are the ones who are providing input to the biomechanical engineers so that they can develop these dummies. These specialties are not at cross purposes. They're just being put to a cross purpose in this particular setting. This is almost unique.
No, they work with clinicians in the diagnosis of shaken baby syndrome.
No, not in the actual diagnosis. I'm just talking in
I'm
broad.
not in this particular case, but in the overall history of
No.
coming up with.
No, that's
No.
wrong.
Okay.
Clinicians, the diagnostic team, do not include biomechanical engineers. They work with other specialties. They work with child abuse specialists, but they do not work with engineers. Engineers work in a research laboratory, and they work with computer models. Yes, they will work on biofidelic dummies, but those are developed separately in conjunction with either clinicians, research physicians, or others, but they don't work on actual active cases of AHT, not that we're aware of. Well, that I guess ends my time here today. I guess I will not be talking about why it is so important, but we thank the court for the time. Thank you.
Thank you, Your Honors. Let me start with what we just heard about how we know that shaken baby syndrome is a real thing, that these particular injuries can be caused specifically by shaking. What you heard from Mr. Porter is the problem, which is that the arguments that they make are circular, that shaken baby syndrome is taught to them in medical school. It was first devised as a theory by Dr. Guthkelch back in 1971. He, in 2012, admitted in his last article that the hypothesis is still not proven, but it's all based on clinical observations. The problem is that shaken baby syndrome is at its core a biomechanical theory. It's just like tennis elbow. Tennis elbow is a biomechanical theory. A patient comes in, has certain injuries to the elbow area, and one hypothesis is that playing tennis very aggressively or playing tennis too long caused those particular injuries. Shaken baby syndrome is a biomechanical theory just like that, the certain thing happening to the human body will cause these particular injuries. And so I'd like to...
That's a really good illustration. So with the example that you just gave, someone comes in and the doctor says, everything that I'm seeing looks like tennis elbow. The patient could say one of two things: I've never played tennis in my life. It's not caused by tennis. Or they could say, well, that makes a lot of sense because I play tennis every day. The
Right.
same could be said in the situations that we're talking about, where if you have someone that states repeatedly, I shook the baby, and then you have a diagnosis of this is what can happen, or and I understand the shaken baby syndrome title. If it wasn't that, it was, if we called it something else. I mean, it could. What you're saying is it could be from shaking a baby, or it could be from something unrelated.
Yes, at the very least, I believe the jury is out about whether shaking can cause these particular symptoms. I would point you to the recent case just 3 weeks ago from the appellate division in New Jersey, State v. Nieves. I filed as a supplemental authority, where the court there fundamentally recognized that shaken baby syndrome is a biomechanical theory, and the biomechanics doesn't prove it, that not a single biomechanical study has supported the hypothesis. And so the jury is still out on this because there is not one documented case of a witnessed shaking of an infant in which these particular symptoms then arose. Now, there are witness shakings of infants, primarily on nanny cams, but not one of those cases to date has been documented as proving the shaken baby syndrome hypothesis. But we don't need to prove, I don't need to disprove the shaken baby syndrome hypothesis to win this case, I would argue, because even the folks on the other side of this debate admit that there are other things besides shaking that can cause these particular symptoms. And one of those things is choking, because choking can cut off oxygen to the brain. Anything that cuts off oxygen to the brain can cause hypoxic ischemia, which among other things can cause bleeding in the brain and swelling in the brain. And once you do anything that increases the pressure of the brain, then you can get retinal hemorrhages. And so several of our experts at the 2017 hearing testified in great detail about hypoxic ischemic encephalopathy, HIE, as an explanation for all of Nikita's symptoms. So while the jury is very much out about whether the fundamental hypothesis of shaken baby syndrome is true, for the purposes of our case, it is enough that there are other causes for these symptoms. And initially, again, back in the day when this case was tried, those were poo-pooed, as Dr. Casson testified. Unless there's something really obvious going on, if you see these three symptoms, it's shaken baby syndrome. And he agreed in 2017 that that's what he had done back in 2016.
Can you address really quickly your opposing counsel's point that it was Judge Kenny who heard the 11 days of evidentiary hearing, and that he would have been the decider of fact anyway, and he wasn't, maybe it should have come in, he heard it, and maybe he just ultimately didn't find it persuasive.
Your Honor, the CREST standard is about a retrial. The CREST standard is, would the new evidence make a reasonable probability of a different outcome on retrial? At a retrial, Judge Kinney will not be the judge in this case. In any retrial after a bench trial conviction, you get a different judge, even if you choose for another bench trial. So even if Ms. Lemons were to choose for another bench trial, she would not have Judge Kinney again. So under the very language of the CREST standard as it's been interpreted in recent cases like People v. Johnson, the test is what would happen at a retrial. And if you had a retrial in this case, a jury, Ms. Lemons, I believe, will go for a jury at a retrial. A jury will hear all of this evidence and would not find that that the evidence is so overwhelming that she has to be reconvicted again without a retrial. Now, I also want to address what opposing counsel said about the confession. So this was a confession in which the interrogation was not recorded. All we know is that Ms. Lemons was arrested on the day that her infant died, her daughter Nikita died. She was held overnight, and she was interrogated sometime the next morning by Chief Williams. We do not know how long that interrogation went. Chief Williams took no notes during that interrogation. All we have is the short written statement that he had Ms. Lemons write out, which for the first time admitted to something other than what she had admitted to Lori, which was that she had attempted to resuscitate the baby who had already lost consciousness. And that is the confession.
I just want to just be clear here. So she used the words resuscitate, not shake.
Right. She didn't. I don't believe she used the word resuscitate with Lori, but what
the two comments that were made to her wife at both hospitals was that she shook the baby
in an attempt to rouse it, to rouse the baby. The baby was
from unconsciousness or
from unconsciousness, and they had seen this situation before, as Lori testified. The baby had stopped breathing before and had to be resuscitated before, and so Miss Lemons told Lori something like, I shook the baby, because I believe people were talking about shaken baby syndrome or the possibility of shaking, and so that's why Miss Lemons was worried about it. But it wasn't until Chief Williams interrogated her after Nikita died that for the first time Miss Lemons wrote that she had shaken the baby before the baby lost consciousness. So that's the confession. There's only one confession in this case, and given everything we know now about confessions that we didn't know in 2006, if this case were retried again, I would expect the defense would vigorously contest the reliability of that confession, just as they will vigorously contest the reliability of the original diagnosis, just as Dr. Casson did himself. And ultimately, at the end of the day, that's what we have. I have never heard of a case in which there's only one expert who testifies at trial that this was a homicide and who then later retracts, and that defendant doesn't get a retrial. This case shouldn't be that first. Thank you.
Thank you. Thank you all. The case will be submitted and we are adjourned.
All right.